with members of the Real Estate Commission to tweak the law next year in the legislature. And one of the proposals is you must be a licensed agent to even engage in wholesaling. All the other stuff would still apply, but just to even engage. Now that rule already exists for options. A lot of people don't know that. If you're doing options, rent to own and things like that, and you're considered a dealer, which the definition of what an options dealer is really broad, you have to be licensed. So they're just gonna extend that to wholesaling. So that's kind of the status of where it's at. We'll see where it goes. One other area that I think there's substantial risk for the wholesaler as well, besides the whole regulatory scheme, which, by the way, the rules and regulations are not final yet. They will be finalized I think it's the third Thursday in August when the commission meets, and that's when the rules and regulations will be put into place. So your cease and desist that you're getting, they're putting it out there. I tried to call Director Lemon this morning to find out if there's been any actual complaints filed, but he didn't respond, and maybe intentionally, I don't know. But there is something I do want to point out here. Here's one of the flaws that I'm seeing that's setting up the wholesalers for some substantial jeopardy when it comes to risk management. Now, remember the scenario I talked about, where Ted and I entered into this contract? Remember, I go out and I find the person to buy my interest. They are called what's known as an assignee. They are the assignee of the contract. I'm assigning all my rights and interest in this purchase contract to this person. That includes, and here's where no one's doing, and I've seen hundreds of these transactions over the years. Make sure you're assigning also the seller property condition disclosure and the lead-based paint disclosure. I'm going to talk more about that in a minute, why that's important. But if you go out and you find the seller, they're required to do the seller property condition disclosure. You're required to sign it because you're the purchaser, and then you have to transfer that. That includes the lead-based paint disclosure, and if I was you, I would do 2 lead-based paint disclosures. One for you and the seller, and then one ultimately for the seller and the assignee. And the assignee must sign that disclosure, the lead-based paint disclosure, prior to the assignment contract. Otherwise, it's a voidable contract, meaning the assignee can walk. That's a federal regulation that's built into Section 1031 of the Lead-Based Paint Hazard Reduction Act. No one's doing it. And when is an issue an issue? Only it's an issue. And then you would have wished you would have done it. So I'm just trying to give you some advice here. You guys do whatever you want, but I thought it was probably something that you probably should know about. So I do want to put out a statistic here. Everybody has their own opinions on whether or not wholesaling is good or bad, and I think both sides are legitimate to a certain extent here. But as I said earlier, I got involved in this when the real estate agents started getting involved, and they started sending me, I would say, hey, send me a copy of this contract. So since January 5th, when I started collecting these, I have in my possession 61 wholesaling transactions from maybe a couple of you and many of you that are not here. Half of them happen to be these large national wholesaling companies. And you all know if you're in the business, you know who they are. So out of the 62, that I have, 41 out of the 62 had grossly inaccurate market value indicated in the language or the email or the marketing material between the seller and the wholesaler. I seen one where the wholesaler told the seller that they estimated their property was worth about $126,000. I'm going to have to do $40,000 in repairs, but I'll give you a break and I'll buy it for $100,000. The property was actually marked. If I was as a real estate agent, I would have easily put it on the market at that time for $275,000. But they put it in writing. That creates a higher standard of liability. Secondly is 38 out of the 62, the wholesaler indicated that they were going to do the repairs. That's why they were asking for $30 or $40 or $50,000 less. Then they weren't doing the repairs. That's how you get the Attorney General involved, right? Third thing, this is legitimate. So out of the 62, 21 had a limited power of attorney. And sometimes I can see where that's necessary because you're getting the seller's permission to remarket the property. But the interesting thing is 21 out of the 62 had limited power of attorney and 16 had a general power of attorney. Anybody know how dangerous that is? I think either wholesalers that do that fall in one of two categories. Either they know what they're doing and they're going to use that to their advantage if they need to, or they're just getting this stuff off the internet. They think they're a wholesaler, and this is what everybody else is doing, so a general power of attorney. And why this is dangerous, I actually sent these two to the Attorney Generals because the wholesaler had a 90-day contract, and then the wholesaler extended that contract on behalf of the seller using the general power of attorney for an additional 90 days. So I did send that one off because that's just predatory. There's no reason why and you know what? That wholesaler could go down and drain that seller's bank accounts. I mean, general power of attorney, they can do anything. I think it's very relevant to have a limited power of attorney, depending on what it says, but not a general. These are the things that we're seeing. And the point is, this is just me and my limited sphere of influence. Imagine what the Real Estate Commission and the Attorney General's office has. And a lot of these are coming from these large national companies that are coming in. So I've been around this industry a long time. I know the people, many of the people that are doing it, you know, they try to do it the right way, but obviously you know that one person screws it up for everybody, and that's exactly what's happened. So make sure that you're doing those disclosures and make sure that you're being honest. Now, when the law passes, well, let's back up here. Whether the law is updated next year to say that all wholesalers must be licensed or you must use a licensed agent, either way it's going to change the game. Right now, if you're licensed, technically and legally, if you're buying a rental property on your own and you're licensed, you have a duty to inform that seller, unless that seller is represented by another agent, which a lot of times they're not. You have a duty to let them know what the market value is. And you better get it in writing. Hey, your property's worth 150, but I'm going to offer you 105 because of X, Y, and Z. Otherwise, when is an issue an issue? When it's an issue, and the Real Estate Commission will crush you if you don't make that disclosure and have it in writing. And I've seen that over and over. So that's the basics of LB892, and where it's going to end up, I think it's pretty clear. In the end, I think it's going to be really difficult in Nebraska to effectively do wholesaling. That's my opinion. And I'm going to talk about a few other things, and we can open it up for Q&A at the end here. But again, hands of those of you who are landlords or property managers. Be proud of that up high. The industry's changing. One of the things that I decided to do early in my career is get into consulting. Now, everything we're going to talk about is for residential zone property. It has nothing to do with commercial. Sorry if you're a commercial person. I'm useless in that area. But there are a couple of things that you all need to be aware of. And the first one is the war against housing providers is on. And you have no idea what's happening behind the scenes. And everybody needs to prepare for some heavy rolls because it's going to get ugly in the next couple of years. And the reason I know this is I still do consulting. I have a lot of clients in California, in New Jersey, Maryland, and it's real. Now, what are we seeing? Rent control. We're seeing licensing. We're seeing everything. And I want to kind of break this down, but I want to talk about the most dangerous thing that I'm seeing. There was a time in my real estate career, my landlording career, I had over 100 single-family homes. And this would have been in the late 2000s, mid-2000s. And a client of mine on the East Coast had about 50 or 60 single-family homes in a small multi-units built prior to 1978. So what's the issue? Lead. The tenants got together and sued him because the tenant's children had disabilities that was proven that it was from lead paint, and bankrupted them. $15 million in a portfolio devastated. And I get this, well, my LLC will protect me, etc. It does not. There's nothing in this business, nothing. I could have a house that burns down. I could have a tenant that dies, and as tragic as that is, I still can have enough insurance financially to protect me. There's nothing to protect you from lead cases. And that matters. Keep this in mind. There's two venues that the nonprofits are going to use against you, and that is who really the enemy is. And I say this kindly. I know I'm being videotaped here, but every federal agency uses the nonprofits to do their bidding. You all know that, right? Fair housing nonprofits go out and do it for HUD, etc. The EPA has a whole litany of nonprofits that do their bidding. And there's a couple of things that are happening out there with lead. Number one is the EPA doesn't really want to do a lot of enforcement, and they're not. They'll only do it when they have to get involved. But they are recommending, so what they're doing is in states that have the requirement for lead testing at the kindergarten physical, the kid pops positive at their physical for high lead in their blood, where's the first place they go? The house. You're guilty till proven innocent. So the nonprofit gets that information. Then the nonprofit sets them up with an attorney, because right now, and listen, I don't want to minimize the danger of lead. Lead is extremely dangerous. My wife was a resource special ed teacher for many years, and I've actually seen a lot of kids that have gotten lead poisoning, and they're messed up for life. It's a tragic thing. But the court system values them at about $1.2 million per child. That's kind of the remedy, if you will, the financial remedy. And what we're seeing is tenants sue landlords because their children has high levels of lead. You call your insurance company, you're not protected, and good luck getting any kind of coverage that's going to protect you from that. And number two, there is a federal law called the Comprehensive Environmental Reclamation Liability Act, CERCLA for short, C-E-R-C-L-A. It's a super fund, but it allows a judge to dissolve entities like LLCs and S corporations and trusts in these matters, so your tenant has, or the plaintiff has, access to your personal funds. And I've seen this over and over and over and over and over. In fact, it's been used against cities when it comes to landfills that needed cleaned up. And the point of all of this is, where it all boils down to, is how is your maintenance? If you are not using RRP, renovation, repair, and painting contractors, you're toast if you get sued or audited by the EPA, period. End of discussion. How many of you don't know what that is, RRP? If you own rental property, you manage rental property, and you own or you manage pre-78 houses, federal regulation called the Renovation, Repair, and Paint Rule went into effect in 2010. You must use an EPA certified contract. And I'm not going to go into the details of how you do that, but if you're doing repairs yourself, you must be certified or use a certified contractor. Third-party managers, this changed March 21st, 2022. Third-party managers only. You must be RRP certified, period. It used to be that as long as you were using an RRP certified contractor, you were fine. Not anymore. You have to be. And in 2 years, they're scheduled to do registration, where every property manager is going to have to register their company. So just heads up. Now, what that means is you have to use lead-safe practices during any kind of remediation or repair that disturbs more than 2 square foot interior. 6 square feet, 2 feet by 3 feet, for sale sign. If you disturb an area greater than that, you have to use lead-safe practices. You have to use an RRP certified. I'm going to leave it at that. RRP, if you go to Google and say RRP plus EPA, it'll come up. There is a big investor here in Omaha, and him and his wife own, I don't know, 300 or 400 properties that just got served notice. They got a lawsuit that's filed against them because the tenants are there are some issues with the tenants. There was another investor here in Omaha that owns 250 pre-78, and they just got notice of a federal case. Somebody filed a federal lawsuit against them. First question that's going to be at the deposition is, did you use RRP certified contractors? If the answer is no, they're going to probably recommend you start settling. So I just wanted to make that you guys aware. Again, my opinion, but it's a pretty objective opinion. Nothing in this business is more dangerous than lead. Leave it at that. And then last but not least, I want to talk about some landlord-tenant issues that I think that we need to be aware of. Number one is, anybody from Lincoln? City Council debated here last week or the week before about source of income as a protected class. All the nonprofits showed up, and a couple of other government agencies in support of it. That means if it's passed, what's going to happen is you must accept Section 8, Surha, Douglas County, Lincoln, subsidized housing vouchers, etc. You can't discriminate based on source of income. That's going to come to the state of Nebraska. It's going to happen. There's a couple of nonprofits, Together One, Omaha Together, and a couple of them in Lancaster County, one in Grand Island, and there's one I believe in Norfolk. They're getting a lot of funding from private groups, George Soros in particular, that are pushing the ordinance and the entire legislative body. And one of the things that they're really pushing for is housing is a human right, whether you got to pay the mortgage or not, and whether they can pay the rent or not, it doesn't matter. You've all seen that, right? And so we've seen it in the legislature this year where they tried to put a couple of bills through. One was source of income. Big deal if that passes for a lot of people that don't want to deal with Section 8. The other one is representation for eviction, meaning you can't evict your tenant until they are represented by a lawyer, which typically is the public defender's office. The landlord would have to pay, according to the way the law or the bill was written in the legislature this past year, you would have to pay $50 per tenant per year to fund that. That's coming back, and there's a good chance it'll pass this coming legislative cycle. Now, there are about 12 states that already do this, and the average eviction time is 6 months because they can go in and do the continuances, and I'm going to be on vacation, and I have a dental appointment, etc. And that's what happens, and it's done by design. The other thing to even make it even more, enticing to be a landlord, how many of you are familiar with the Creighton Law Department? You know what they're doing? Anybody want to guess? Yeah, they're sitting at the courthouse. That's how they're training their law students, right? So anybody know who the dean of Creighton Law is? Well, so it was interesting. He funded, or he didn't, I take that back. He didn't fund. There was a group, a special interest group that believes in the same cause, funded a study that said, and this is interesting, in the study it said 96% of all lease agreements in the state of Nebraska are illegal. Now, it's how he interprets certain parts of the statute. Point is, that gives, the reason that the representation at eviction didn't happen this year, because they couldn't get enough senators to find cover. This study is going to give them the cover that they need. I'm telling you. And that it's by design. I do think by this time next year, tenants are going to have the right to representation for free at evictions based on that. So we can look forward to that. All of this is the cost of doing business, right? So, and the last thing I want to talk about, and then I'm going to open it up for questions if that's all right, Ted, if you have any members left after this. I'm always, when I go to speak and I bring this stuff up, I feel passionate about this. Like, you guys got to know this, right? You have a lot of busy lives, and these are the things that creep in underneath. And I'm just one of these nerds that like to pay attention to this stuff and get the information out. I'm always like Debbie Downer, and they're like, please never come back. But how many of you know that the city of Omaha is conducting a 4-phased affordable housing study? How many of you knew that? So this is cut and paste from every major metropolitan area that has rent control and other things. And it's, again, it gives the cover politically for mayors and city council members to support these kind of regulations. Well, they're in phase 1, or part 1 of the 4-part study. And if you look at who the principals or the stakeholders are in this study, all of them are nonprofits or people that don't like our industry. And there's really no representation from our side by design. And all you have to do is go to Cleveland, Chicago, Detroit, Cincinnati, and you're going to see the same game plan, right? So what does that mean? Well, once the study's done, then it's going to go to the city council, and the study is also going to go to the Lincoln City Council and Grand Island and probably the legislature. And what we see out of that, the genesis that is birthed out of those type of studies, is number one, we typically see an inspection and rental property registration. Now, we already have that here. And if you didn't know it, there's some interesting stats about that. There are a little over 19,000 people that have registered, owners that have registered, representing about 98,000 doors, and over 50% of the doors are foreign-owned, meaning they're out-of-state owners. So in that regard, it's a good thing that we know that, because one thing that we do know from legitimate studies is a housing stock of a community is decimated by foreign owners, or what we call them foreign owners, but they're out-of-state owners. And the city does have to do something about that. Separate issue, but it's going to be used, that data is going to be used along with this 4-part study to justify rent control of some form, and there are many different forms of rent control that are out there. Some of them are very punitive, some of them are just a pain in the butt. California, the reason that tenants love the rent control in California, by the way, California now, the entire state is under rent control, but there were counties and cities that would have it. And San Francisco, for example, if your tenant rented your property 30 years ago at $250 a month and they're still there, guess what their rent is? $250 a month. You can't raise rent until they move. And that's just one form. We don't know what we're going to get. In New York City, they have a board, a landlord board, that determines 3-bedroom, 2-bath, 1-car garage, here's what your rent is. Somebody makes that determination for you. That's coming. I think you all know that, right? But they're going to use this study. The other thing this is new. I started seeing this pop up with some of my clients about 18 months ago. What cities are doing, they're using the business licensing method to regulate the rental property industry. And what they will do is say, before we'll issue you a business license to operate your rental property, you have to prove to us that you are financially solvent. So that means you either got to turn your books over to an auditor with the city, or you have to have a CPA audit it and then turn it into the city. They'll give them a certificate of satisfaction, so then the city doesn't have access to your actual finances. But without that, and if you don't meet the certain thresholds, then they will not issue you a license, which means you're going to sell your portfolio. A lot of the cities are going to that to save the housing stock. I get it. I mean, I actually get that a little bit, because what we find is properties that are when an owner milks a property, it destroys the housing stock in a community. It just does, and that is absolute fact, and there are good studies that can back that up. How these things are going to be administered, I don't know, but it's coming down, and that is the reason for the affordable housing study that's happening. So a lot of things are happening, and I don't have the time in this particular class. What the alternative at this point, what we're seeing and how we overcome this, all of these things are the cost of doing business, and who's going to pay the cost? That's right. Say that really loud for me. Pass it on to the renters. When you guys go to city council and you tell a city council member that, they're hoping you do. How many of you took debate in high school or college? A good debater is going to put their premise out there and know what the response is going to be from the opponent. And they're banking on you saying, well, then that's just going to cause, that's going to increase the cost of the tenant. And then the opponent says, that's why we need rent control. That argument does not work. Who bears the cost? You do. I think it behooves everybody in this room that is a landlord or you're a manager to have this discussion with your owner to do three things. Number one, how do you run your operation more efficiently? Cut costs and be efficient. Number two is you need to come up with anticipation of risk, anticipated risk. So we're looking out 2, 3, 4 years. What is it going to look like for me, and how am I going to overcome that? How am I going to fund it? Those type of things. I'm going to tell you, as the East and the West Coast, they collaborate and they move inland, we're going to see less and less places that are actually going to legally allow you to take money out for refinancing, and that's what we do. Property appreciates $200,000, you pull $80,000 out and you buy something else. That's going to be less and less likely as time goes on. And the third thing is you need to be creative with your revenue generation. You're a for-profit business. Everything that you do in your business, whether it's a property management, whether it's a landlording business, should generate revenue. I don't care if it's 50 cents or if it's $5 million, every process. I'm always amazed at how many people don't charge an application fee. Why aren't you doing that? Why aren't you making money? Why aren't it $40, $50 for an application fee? How much does it cost you to do a background check through tenant data? 20 bucks? Make $30 for your time. Grace periods. How many of you offer grace periods on your leases? How many do the 3rd? Rent's due late on the 5th. Why are you offering that for free? Rent's due and late on the 1st. If you want the 3rd, great. It's $50 more. Oh, you want the 5th? That's $125. What's that? Well, ethics and morals, although there is a certain standard for that in the business, in the end, that's not an unethical or immoral fee. It is an amenity. The implied standard is rent's due on the 1st. In every state in America. In fact, you go to England, rent's due on the 1st of the month. If they want the luxury of going over, there you go. Start getting creative. I teach a whole class at Randall. It's a 3-hour class on fee-based property management, because that's where it's going. And it is amazing how much money we're leaving at the table by doing simple adjustments like that. How many of you own properties in Sarpy County? Any military tenants? Do you have a rent's due twice a month on the 1st and the 15th when they get paid? Rent's $1,000 on the 1st, but if they want to pay on the 1st and the 15th, it's $600 on the 1st, $600 on the 15th. Very popular. This is what I'm talking about, fee-based. Start looking at creative ways. Go to YouTube, because otherwise, when all this stuff starts coming down, and it's coming, a lot of people are going to get crushed. Because you're operating based on your current cash flow structures, and it takes a lot of time to get those things revved up starting out. And I'm going to tell you guys something right now, the tenants are paying it. Maybe a time when they won't, but they're paying it. They love the options. All right, Ted, how did I do? Did I meet the expectation of the temp agency that you hired me from?
I think we're going to have lots of questions.
All right, I'm going to open it up for questions.
So just so you guys know, we have microphones in the middle. If you're not able to get to a microphone, raise your hand. I'll come to you. So if you have questions, please go up to the microphone, and then Paul will call on you. I do have a question while we're waiting for people to come up. How will this be regulated? Is this going to be regulated, as far as the wholesale laws, will this be regulated through the title companies? Like, how are we going to regulate an actual wholesale?
So what's going to happen is it's going to be regulated solely by the Nebraska Real Estate Commission, and that is complaint-based, meaning somebody has to report it and turn it in. They don't have to actually file a complaint. They just have to make them aware, but that's how it's going to be enforced. And the Real Estate Commission does have jurisdiction over non-licensed people. So that's going to be the enforcement mechanism. If it's egregious and they discover that you're practicing law without a license, which dealing in contracts can be, then they can refer it to the Attorney General's office for prosecution.
So my question, you said
what's your name?
Dupree Sears with Black Power Redevelopers, electrician and landlord. So my question is the Section 8. So you said people that own property have to take Section 8?
Not now, but one of the source of income is a protected class under fair housing. Well, in many states. It's not at the federal level, but one of the things Nebraska and many jurisdictions, including Lincoln, is trying to push is, in their local and state law, is to have source of income as a protected class. And when that passes, it can mean a couple of things depending on how it's framed. One of them, the most common, is landlords and managers would no longer be able to say no to Section 8 tenants or applicants, or like if you're in Iowa, it's Surha, or Douglas County vouchers and stuff like that. There is another aspect to that. Many jurisdictions in California and Illinois have this, where you can't even ask the tenant for their income, and you cannot verify their income. It's called stated income. In that case, you have to exclude that in your screening tool, or you have to say, oh, Section 8, no big deal, let's bring it on.
My honest opinion, I think it's fair because I know I'm from poverty, you know
Sure.
what I mean? So a lot of people that I do know is on Section 8, and they always come. That's why I started renting to Section 8, because a lot of people are like, oh, don't nobody want to rent to Section 8. And you got all these people in here that own all these houses but don't want to rent to Section 8 or discriminate against Section 8. And it's really not a big deal because they inspect the property before you rent it out. If the tenant messed it up, then they go ahead and reimburse you so that you can get it fixed. And then secondly, it's a guaranteed check. Like,
Sure.
Y'all dealing with people that don't even want to pay. They probably lost their jobs during COVID, but yet my Section 8 people, I'm getting my check every month, you know what I mean? So it's guaranteed. So it's like.
First of all, let me say this. I admire you for doing that. And there's
definitely.
nothing wrong with Section 8. Here's the problem. It's not the Section 8 and it's not the tenants. It has nothing to do with that. And I think most of the people that have ever did Section 8 will attest to this. It's the establishment that screws it up. You get inspectors, one inspector will say one thing and another inspector will re-inspect and say, no, that's wrong. It's like city code. Or it'll take months to get a check and then they have their favorites. We're going to pay you right away. You're going to get yours 3 months. That's the problem with Section 8. And who ultimately gets screwed in the process?
If you got money, you got money.
The tenants do.
I mean, the tenants don't get screwed. My tenants moved right away, but I did wait like 2 months to get a Section 8 check, but they paid 1 month and sent the rest of the money. I mean,
so let me give you another example. I had a landlord here in Omaha call me and said, I don't know what to do because the tenant, Section 8 has been paying, right? And the tenant section or part of the rent is like $35, and the tenant's been paying. So all of a sudden, the landlord gets a $56,000 check. And they're like, what do I do with it? And they said, well, this is for your tenant pool and this address and this address. And they're like, well, no, we've already been paid. So they're like, well, we're not taking it back. So then what do? The next month, they totally cut off all the funding because they were overpaid.
Yeah, that sounds like a bigger problem.
That's what I mean. That's the problem with Section 8 in general, is not the fact that they're helping tenants out. Tenants get screwed in this process because then you get landlords that won't take Section 8 because of the inspections and the crap that they do and the favoritism that they... Listen, I did Section 8 for a couple of years and then I said no more. Yeah. Because they would come and one inspector would make me remove drywall and another inspector would say, no, that's fine.
That's part of the business, right? I mean, as an electrician, you get... one inspector like, hey, it need to be GFCI because it's within 6 feet. And
sure.
then the other inspector like, oh, well, it's a doorway. It's not within 6 feet.
Shouldn't be that way, though.
I mean, it is.
And then you multiply that by 200 units, that's the problem.
The chance, but I mean, you multiply 200, use a guaranteed check. You're gonna have to deal with something, but I think it's a good thing because it's a lot of discrimination with people that do have Section 8.
I think what needs to happen as a community, we need to demand from, I mean, listen, this is my opinion. Where's the video? My opinion only, not the opinion of RIA whatsoever. OHA is the worst landlord on the planet. They are. As far as look at Jackson Tower, right? I mean, and that, who gets punished? It's always the tenant that gets punished. Let's demand that, this is taxpayer funded, let's demand that there's some leadership and get Section 8 fixed, and then more people would do it. So, thanks, man, I appreciate it. Yes?
Hi, my name is Jenny, and I have a two-part question.
Sure.
How can I handle ESAs when they don't tell me that they're moving in with one,
Okay.
and I have an apartment building that can't handle large dogs tromping around and smoking, where they say they don't smoke, but they do?
Yeah.
How many 1430s can I give them before I go to court?
You give them as many 1430s as you possibly can until they move or you evict them. Now remember, if you file for restitution under the 1430, you have to prove that they're in breach or violation. Your best chances are very difficult. So your best chances is the tenant doesn't show up and you get a default judgment. Otherwise, you got to bring witnesses in, and it's next to impossible. By the way, and I want to follow up on that, for you guys that are 1430s using those, make sure that you make a citation of what paragraph or provision in the lease or what law they broke, and a detailed description of the breach that what is the tenant doing that led to the breach? That has to be in your 1430, or the judges are starting to throw it out.
Do you have to give them the lease again? Would that help?
You can. Certainly, it's not required. It's not required. Now, the ESA thing is a little bit, no, by the way, lesson to everybody here, do not hand deliver your notices anymore. We're starting to see judges, county judges, throw them out, even if you take a photo of them. How do we send our notices? First class mail, not certified, not registered. The statute only requires first class mail. There's not a requirement that you prove that the tenant received it. If you send it certified or registered, the judge is going to, and the tenant shows up and says, hey, I never received it, you voluntarily agree to a stricter service notice. Don't do it. First class mail, that's all you need to do, and don't do hand delivery. ESAs, actually under fair housing, ESAs are now called assistance animals, and here's the thing, at this point you have not been notified or ran through your process. So even if it's an ESA that they brought over, it's a pet to you until such time it becomes an ESA. So what you have to do is say, 1430, you got a pet, get out. Then they're going to come down and say, yeah, but it's an ESA or a comfort animal or whatever. Fine, then here's my process, here's what I need you to do so we can get it, so I can verify this. And then run them through your process and determine whether or not it's legitimate or it's not. And if it's not, then evict them both. If it is, then you can't charge them pet rent and pet deposit and stuff. But just because they declare it an ESA, or they'll say, hey, this is a certified, I have documentation that this is a service animal, doesn't matter. You have to establish, number one, that they have a disability that requires the assistance of the animal, and they have made the request, and you verify the information. Now, as far as the dog, and this is a general statement. If it's a pet, we can discriminate however we want. Breeds, male, female, black, white, poundage, it doesn't matter. If it's an assistance animal, you almost never say no. Yeah, it may be a huge dog that weighs 250 pounds and it's destroying it doesn't matter. You can't say no. The only way you can say no is if you can overwhelmingly and objectively prove that it was destroying the property or it was a threat to somebody else in the community. La Vista. How many of you have properties in La Vista? So La Vista had a ordinance that said you can't have chickens, right? Tenant says, I'm entitled to an assistance animal, which I want a chicken. And they were legally entitled to this assistance animal. Landlord said, I don't care, but La Vista said they would prosecute me if I allowed it. La Vista would not capitulate. They said, no, it's an ordinance. So then the Fair Housing Center of Iowa and Nebraska filed a fair housing complaint against La Vista. And guess what? Guess what are now legitimate assistance animals in La Vista? Chickens. My advice to you guys, if you are in a position where you're going to say no to a request for an assistance animal from your tenant, before you do it, have the conversation with your attorney 100% of the time, because it will lead to a fair housing complaint, and that's going to be 9 months at the Equal Opportunity Commission in Lincoln and probably $15,000 to $25,000 in legal fees, even if you're proven right. In the back, yes.
Hey, Paul, I have a lot of questions, comments, so cut me off when you need to. But first off, I've watched some of your content and appreciate all the things you have to say. You're
Appreciate
a phenomenal authority in what's going on around here.
Thank you.
You also made a comment, I guess I'm going to back up this a little more, on your limited power of influence in your sphere, and I just wanted to call BS on that because you have a lot of it. So speak what you got and say it loud, and we'll be here for the backside of that. Man, so many questions. One of the previous questions was talking about Section 8 housing.
Mm-hmm.
I guess my concern with that in general is, at what point do we get concerned as landlords and owners about accepting government funds to wring our necks on their regulation later? So your example said $35 a month. That's what's left for the tenant. But if we open ourselves up to accept the government money less than $35 a month, how much regulation are they going to shove down our throat before we can't even accept
As much
tenants
as
we want?
we allow them and as much as they can get away with.
So you go to California, or you were talking about California earlier. I'm in a group with some people in Minnesota that said they are legally now not allowed to raise rent more than 3% a year.
Right.
Doesn't matter what happens, they can't raise rent more than 3% a year.
Form of
Somebody
rent
can trash
control.
it. Yeah. $50,000 turnover, doesn't matter, 3%. New tenants, doesn't matter. Like, those things scare me a lot with the government overreach. And I think the only
what's
way
the
to
answer? I mean, and you bring up a good point, but what can you do about it, or you, or you, or you? What can you do? You can't. These are written into regulation, not so much the law. It's the bureaucrats that really create the regulation. If you read the LB892, the law itself, I think there's maybe 40 words that they changed in an existing statute, but it's the 44 pages of regulation that's going to be written after the fact. And there's no way to counter that other than maybe spend a lot of money in legal fees. So that's why I'm telling you guys, you need to look at your business models and anticipate what's coming down. Number one, decide whether or not you want to stay in the business. Number two is, what is that going to look like if X, Y, and Z happens? And that's what we have to do. It's either illegal or it's not, and you have to comply if you're going to be in the business. I hate to be brutal, but that's just the answer.
I feel like a lot of it surrounds logic and common sense, and that's hard to get around when it comes to government overreach. But if you will take things internally and focus on the tenant and their needs in a direct way,
I get it.
Versus relying on assistance.
But see
for
here,
that
guys,
money.
everybody has to understand this. In the legislative process, no matter if it's landlord, tenant, or other, there is special interest groups and special interests that are involved in everything. And right now, it's the tenant special interest groups, they say that they are, that have all the funding. And they're winning. And then we go to the city council to oppose an ordinance, and we go there and we make ourselves look like idiots. There's nothing, there's nothing that I hate more when there's something before the city council and the landlord and community shows up. It was like, hey, could you at least taken a shower last Saturday before you came? And I see that all the time. It is so frustrating. Then the third-party managers and the Realtors Association really won't get involved because landlord is a negative connotation. I don't want to be associated with that. So the cards are stacked against the housing provider world, and until that changes, we're going to have to suffer the consequences. One more question there.
All right,
Pick your best one.
Probably not my best one. When you got into lead-based paint,
Yes.
how is that? How many cases are there that actually are proven to be related to issues like none of us want children having problems with
Sure.
lead poisoning? Is that real? I mean, all I can imagine is, Chris Farley getting sprayed by water in the gas station. Don't eat don't eat the paint. Like,
So just to
How
illustrate, I
rough
mean
is
this sincerely. 1 gram of lead-based paint can cause permanent damage and substantial motor skill damage.
But we're talking about open. It's almost like asbestos, right? It needs agitated to be released.
Right.
More or less, right? So
No,
if it's
no.
encapsulated,
Well-
like talking with government officials locally, you will get money up to $15,000 per house if you paint over it. And there is nothing that says you need to use a certified, I forget the term.
RRP says you have to.
Certified person to paint over that.
And
Even
that's a
the local
Section 8
government
requirement,
says
too.
no. They don't require that. But
Well-
yet they will give you the money to do that for your normal painter.
Right. The bottom line is a kid's either going to test positive or test negative. If they test positive, what you really got to know is they're going to look at you first. And then after that, they're going to look at your maintenance records, which you must provide either in a deposition or an EPA auditor. And if you cannot prove that you didn't use RRP requirements, the certification, the work history, the practices and all of that, you're toast. That's the reality of it. Here's the thing, the biggest dispute that we get, and there's usually about 200, maybe 300 cases across the United States where tenants sue in federal or state courts or some local jurisdictions. There's always a kid that tested positive, and then it becomes the costly part of it is where did the lead come from?
Does it have any longevity on, they've been here 3 weeks and the kid tested positive, or they've been here 3 years? Is there a line there that matters at all?
Oh,
Or
that's a great
they
question.
were in your facility, you're screwed.
Yeah, pretty much. And also under the CERCLA law that we talked about, and also the Recourse Conservation and Recovery Act, which is another environmental law, federal law, is they are allowed to sue every owner of chain of title that's still alive.
So none of the disclosures matter at that point.
No, it does from an enforcement point of view, and it also shows that during depositions and the culpability side of a lawsuit that you were doing things right.
So would they cut it on the previous owner with the disclosure
It's
filled
up to the
out?
judge and who gets sued. I have seen them go back as many as 10 owners ago. If there's an estate that's still open, they're going to go after they can. Not that they will, but they can. So why don't you hit me up after when we're done here and we can talk some more. No, you're good. Thank you. Yes.
Yeah, thank you, Paul. I'm going to just make an assumption that radon gas is going to be the next great thing to happen after lead base.
Wherever the money is.
Wherever the
Do we have any
money's at.
radon mitigators in here?
So getting ahead of the game and planning on them is about the best thing you can do for right now.
Right.
Also, the money thing is so shifting away from rent and creating a lot of things that produce income that are not rent.
Yes.
Rent's control, but those other fees don't have any controls in place on those?
Well,
Or some kind of...
yeah, so what's happening, like in parts of California, they're starting to get wise to the management fee, or, the fee-based management. But let me give you an example. How many of you are real estate sales here in Omaha? How many of you know what a broker administrative commission is that we charge our buyers and sellers, right?
Yep.
We should be charging our tenants the same thing. Not as much, but right now there's property management companies in C-class properties in Omaha, and they're getting anywhere from $150 to $350 at the lease signing. It's called if you're a third-party manager, you have to call it a broker administrative commission. You must under RESPA. Landlords, you can call it whatever you want. Doc prep fee. Now you have 50 homes, and let's say you have just the numbers, you're charging $250 and you have 15 homes that come vacant for new leases every year. Do the math. 250 times 15, pure profit. Tenants are paying it. One of my favorites that we do is if it's a pre-78 home, it's automatic per tenant, not per lease, but per tenant. It's $11.95 monthly environmental compliance fee. And I actually have a list of about 100 of them. But that's where it's going.
So essentially come up with fees like I got to check and see if there's environmentally clean and just charge them a fee per month.
Absolutely.
Yeah, they might have changed their oil and I got to clean it up and then I got to charge them for an EPA guy to come clean up the oil. I mean, that's what it's going to come down to. And if they smoke, it's a hazardous condition, right? It's a known carcinogen to smoking, so I'm going to have to charge them for smoking.
Absolutely. And oh, by the way, if it's smoke-free, I'm going to charge you more for that.
By the way, pets are also contagion. They get a lot of contagion stuff. If they let the weeds grow, I can charge them for weed control because, you know, weeds got to be kept down. That's an ordinance. It's a state ordinance. I mean, you know, if you'd enforce it.
One other thing I want to point, there are a couple of judges now that have actually, how many of you have issues with smokers in a smoke-free, right? Try the 5-day notice, the clear and present danger notice.
They won't recognize 5-day notice.
Some judges do, some don't, but we've successfully evicted a couple of tenants on that because of the carcinogen that you had mentioned. Where you at? Where'd you run off to? The carcinogen aspect, the particulates. So.
By the way, I'm thinking about going on to become a lawyer because this has got to be fun.
Yes, sir.
I'll take you back to the lead-based paint conversation.
Sure.
I own a house built in 1966, looking to move out and rent it. It's been painted by me a few times, and so lead-based paint, I'm obviously going to have to disclose it. Do you have any recommendations for how I treat that? Do I need to try to cover it with siding, remove it and replace it?
Well, you don't want to do that until you know if there's actually lead-based paint in it, which requires testing, and then you have to disclose that for the rest of your life and the rest of the next owner and the next owner. At this point, what I would tell you is just make sure that you, if it's owner-occupied, you don't have to comply. As soon as your intention is to make this a rental property, that is for compensation. Therefore, either you have to be an RRP certified contractor or an RRP certified contractor has to do the work. They're going to come in and do a lead assessment and do all that before the work. But just to, listen, you can do it the old-fashioned way and say, screw it, I'm going to throw paint and all that on anyways, but at your own risk. And one other thing I do want to clarify, if you just paint, that's it. There's no prep work, no scraping, just rolling, and you do not have, even pre-78, you do not have to use an RRP certified. But as soon as you start scraping a little bit, which we do, chipped paint, then you have to do it.
The risk starts when it's not owner-occupied, though.
Right, exactly. As soon as the intent is for it to be a rental property, then the compensation component comes into play.
Thank you. Does that include interior paints as well? Or just
Exterior, interior. So on the interior, if you're going to disturb more than 6 finished square feet or exterior 20, then the RRP comes into play.
Thank you.
Yes. If you do it after the fact, you've already committed a crime. When is an issue an issue? Only when it's an issue. Yes.
Hi, Paul. I'm Jerry Schlickburn.
Yeah.
I'm the broker for Orange Property Management. Who wants to buy my company? Just kidding. Yeah, $3. Do you have any hopes of Section 8 improving? And the reason that I had a little hope is because they recently asked Ted to participate in some things that the city say they're trying to do to improve it.
They are starting to reach out, and I hope. Just like anything else, though, they'll hire a few people, and then it just seems to implode.
Yeah.
We've seen the same thing with OHA.
Yeah.
Over the decades. It really, here's the thing, it really need, as a group, as a community of investors, MOPOA, you know, all the organizations like MOPOA and the apartment associations, we shouldn't tolerate this crap. As a collective voice, we need to go down to the city and whoever's administering it and wherever you're at and say, we want to do Section 8, but you guys have screwed it up. Here's what we need. Because the tenants, and then get public with it. Channel 7 gets a hold of it and say, listen, we're sick of Section 8 and the inefficiencies, and we want to do Section 8, but it's the bureaucracy. That's when things change. Until that happens, it's not.
Yeah, it's so true, because how many times we've bought houses that have been Section 8 for 30 years, and all of a sudden there's a laundry list of things that need fixed that clearly have been there for 10 years.
Oh yeah, and how many inspections did it pass?
Yeah,
10?
exactly. Are you still a landlord?
I am not personally. I'm in the point in my life where I don't want to own anything. And I'm going to tell you a really disgusting true story. I've gotten to the point in my life where the other day I plugged up the toilet and I didn't even want to walk into the other bathroom to get a plunger. I just wanted to call. But I still actively involved in management. I am actively about 2,000 doors total.
Nice. Airbnbs have become really popular in Omaha, surprisingly, but they tend to do pretty good. I know there's going to be legislation coming down around Airbnbs, but what sort of things are you seeing in that market?
So if you want to know what's going to happen here in the future, just Google Airbnb and government regulation in Florida and you're going to get your answer. Florida is the forefront. They're starting to limit the number of Airbnbs in beach communities because it's soaking up all the housing stock for renters. Then you have the hotel lobby that is pouring big bucks into local, races and stuff like that, because that's who's competing with the hotels. We're going to see a lot of regulation come down on the Airbnbs. And some of them rightfully so, because at least the hotels have certain health and safety requirements, and a lot of Airbnb owners, they don't even check for bed bugs half the time. There was a study that the Heritage Institute did about a year ago, and they found that think about this, compared to the number of hotel rooms versus Airbnbs is out there, Airbnbs, that about 20% of the bed bug spread originated in the Airbnb. But yet the total number of hotel rooms is about 150 times the number of Airbnbs. So.
My final question is, what do you see for the future? Like, I have my own ideas, but who buys rental properties in California anymore?
I love that question. Do you know who the biggest landlord in Omaha as an industry is? Anybody want to take a guess? What's that? Churches. What we're seeing across the United States is the model of investing is changing from owner-occupant and owner-operator to nonprofit. And that's who's buying up a lot of this. And there's a lot of reasons why. There's some built-in protections from the lead liability and stuff like that. How many of you, and I got this idea one time, how many of you ever driven across like Alabama and Mississippi and Georgia, and in the middle of nowhere you see a Methodist church or a Baptist church in the middle of a field? You know why that is? Because the owner is an ordained pastor and his entire farm is a church, owned by the church, nonprofit. That's what we're seeing. Nonprofits now are becoming enormously, they're becoming the biggest. And it is a model that everyone should actually consider doing. And then you get access to grant money for subsidized housing, low-income housing and stuff legitimately.
Interesting. I was just going to ask, is that something that everybody could, all of a sudden we have 75 nonprofits? I mean.
Well, but here's the thing. When you start a nonprofit, you have the CEO, which is you, because you created it, but what must you create?
A board.
A board. And your board can fire you at any time, so that's why you put your husband, your wife, your kids, your daughter, and then they're all on salary. And then you as a CEO, you pay yourself a large salary up front because you're not going to get the benefit of the property being sold 30 years from now unless you sell the property and then bonus the entire board of directors. There's a lot of ways to slay that cat, and I don't like cats, so I'm okay saying that. Sorry if I offended you. In this business, there's nothing more evil than a cat, except a cat that smokes. Personal
great.
opinion.
That's great information, though. Thank you so much.
You bet.
I really appreciate it.
What's that? It should. Yes, sir.
Hey, Paul. My name's Travis. First and foremost, I'm a cat owner, so I appreciate it.
Does it smoke? Yeah, good question.
So for me, I currently am in an acquisition LLC, and I kind of operate outside of Nebraska because of the new law. But how I usually work is I find my buyers first, and I kind of get my buyers' box to find what they're looking for, and then I find things for them in that box. So in that regard, what's to stop me in Nebraska from doing that on a property I don't have equitable title on, finding the box, getting the buyer to the seller, and then getting a finder's fee for that? What's to stop me from doing that?
That is a license law violation.
Okay.
You can't, and you're operating in an area that requires a license. That's a licensed activity.
Okay. Thank you.
You bet.
I didn't mention something, Paul. I don't know if you know that yesterday, the FTC, the Federal Trade Commission, fined somebody called Open Door. It's an iPlatform. They were buying houses, and they were doing all the same things that wholesalers were doing. And they got fined $62 million. So what you're talking about with wholesalers, it's going to get nasty, really.
It is.
It is not, legitimately speaking, you should find somebody that has a license that knows how to follow
Just
the
get
rules.
licensed.
Yeah, and you can get a license. Anybody can get a license.
That's right. I can attest to that. I'm licensed. And Randall School of Real Estate, the best.
So there's a lot of realtors in the room, and if a realtor got approached by a wholesaler, what would be the best course of action so that they could legally purchase that property or get that property to a potential buyer?
I'm glad you brought that up because I forgot to talk about the MLS issue with it. So if you want to sell your equitable title, you have to use a licensed individual. So what you're going to have to do is have that agent go to their broker and find out if that broker will allow that type of transaction. Many brokers are not allowing that transaction. The other thing is just so you know, the MLS rules forbid the marketing in the MLS of equitable title in a contract. However, clear cooperation, it's a policy that the National Association of Realtors have that say that within 24 hours of listing it, it has to be put in the MLS unless it's what we call an office exclusive. There is no exception for anything else. So you're going to be in violation of the MLS rules if you list that equitable title for your client because you can't put it in the MLS, but you need to market it. And Clear Cooperation says that if you market one iota of a detail about that transaction, then you have to tell all the realtors in the MLS. Well, you can't put it in the MLS. So the board of directors of the MLS, they do not like wholesaling, and they're going to meet this month to address it, but I don't see them allowing those type of transactions to be put in the MLS. So that's what I'm saying. Effectively, I don't know how you do it. Unless you could use a non-realtor member. And if you're a realtor that is a member and you're going to, and your broker allows these type of transactions, let me give you a little bit of advice. And only the realtors are going to know what this is, but there is the waiver of benefits. You know what I'm talking about? There is not an exception for this on the waiver of benefits, but what I would do is create my own little box and just write in there, this is a equitable title or equitable interest transaction, and MLS rules would not allow me to put it in the MLS and then sign it. So that way, if they try to fine you, you can at least say, hey, they're not going to fine. That's what I would do. It's the only workaround.
Would an email to all the agents, because we have access to everybody's contact information,
Well, then that's marketing, and under Clear Cooperation, it's required then to be put into the MLS within 24 hours. But the MLS doesn't allow it. But if you don't, then you're going to get fined by the MLS. It's a mess.
So if you have your real estate license, one of the wholesalers in this room call me, let's just use me as an example. Ted, I got a deal, and I'm personally looking for a deal.
Yeah.
What is the route I could purchase that property? Do I have to go to the actual seller of the property, get the paperwork signed with them, and then have a referral fee paid to that wholesaler in that deal? Could that legally be done that way?
Those type of transactions get really complicated because the wholesaler is not licensed. Now they are selling their equitable interest to you, which is fine, right? But now there are certain disclosures and stuff that you have to make as a licensee to the seller, including that you're equitable interest, or that you're a licensed agent and all this other stuff. I would also tell you that if you're buying it at a certain price and you know that that is not the true market value, this seller might come after you later for misrepresentation because of your duty under agency.
In my experience in the past, when I bought off markets, because I do have my license, I had a sheet and we broke it down and said, hey, this is what we think the market value is. This is what rehab would cost. This is
right.
What, if you want to use our services for the construction, this is what that will cost. We will do that for you. Or this is the price I'm willing to pay for it as is, and broke it down all the scenarios and had them sign off on it.
That is, if you didn't hear that, that is the correct way to do it. As long as your numbers are honest. And guys, I know I get these people that'll say, well, a house is worth what I think it's worth. Shut up. There's a lot of data that's out there that can justify a market value, including the MLS and other things. Be honest in your numbers if you're licensed, whether you're representing the wholesaler or you're doing it yourself. And then what you're going to have to do is make sure that one other thing on that because you're using an assignment contract, make sure you make your disclosure that you're an agent, and make sure that your disclosures are done. Seller property condition and lead-based paint. And that assignee cannot sign that lead-based paint, the assignment contract until the lead-based paint has been done. Otherwise, it's a voidable contract. Yes, did that answer that, Ted? Good?
Hi, my name's Kim.
Hi.
And I'm new to this whole thing.
Welcome. Are
Thank
you
you.
a member?
Not yet.
What? Do we have a membership form somewhere we can get in?
My question is for the wholesaling, couldn't they do a to B, B to C type of thing?
Double closings and all of that, no. It's still, the process is mechanics is still going to be the same between A and B and B and C.
Why
It's
is
just now
that?
two separate transactions.
But why is that?
Because
so if
it's-
I'm buying the house from Ted, and then I'm selling the house to you, I don't understand why.
But how did I find out about it?
Why does it matter if I'm the seller selling it to you?
Because now, are you the wholesaler or the seller? Ted's the seller, right?
But I just bought it from Ted.
Right, so you have equitable title.
Uh-huh.
Now, how did I find out about it? Oh, if you closed on it, then you're the owner and you would fall under the FSBO exemption.
Okay.
So you could do that.
Okay.
But if you were doing the wholesaling, that would be an issue. But if you
Okay,
close
thank you.
on it, and then you're fine.
Okay. Gotcha. So once
Here's
I
what-
close on that, then I can turn around and find a buyer.
Once you close on it, you can market it. But a lot of people, there's a fallacy that let me give you a scenario. You buy it from Ted, but it doesn't close. You find me and you're marketing to me through an email or whatever, you're in violation of the law. And you say, but I'm going to close on it and then sell it to you. Call that a double close. You're still in violation. Before you can contact me, you have to close on it. Otherwise, you're in violation of Nebraska's
Okay.
statute.
Thank you.
You're welcome. Awesome question.
Hey, right before you get to Brad and follow up on that, I heard rumors that there's going to be a seasoning period with closing, like 30 days to avoid that double close. Is that true?
Well, so it's going to depend on this is a lender issue. And we see this with FHA on the flip houses where there's that 90-day rule. FHA actually rescinded that rule many years ago, but many of the lenders, the underwriters, still require that, and they can. It's their money. And we are starting to see 30 to 90 days for these assignments for seasoning period. That's another challenge. Wells Fargo is really anal about that. Well, U.S. Bank too, right? U.S. Bank. Uh-oh, what'd I do with here it is. Yes.
Paul, help me out with your terminology there on the in-house exclusion where you don't have to list it on the MLS.
Say that again.
What was the in-house exclusion internally?
Yeah, so if you're a Realtor member, you list like anything. It has to go in the MLS within 24 hours. That's
Except for,
well, that's clear cooperation policy. There is an exception called the broker exclusive. So I'm at Nebraska Realty. I could list his house, and I could only market it to only Nebraska Realty agents and not have to put it in the MLS.
okay.
But once if one agent or one of your buyers or whatever puts it on a Facebook post, now it's been made public outside of the parameters of the inner office.
But that inner office circle would be anybody under that umbrella of Nebraska Realty.
Right, only the agents. Technically, under clear
So
cooperation.
obviously the agents can communicate with their
Yes.
clients. Jerry, are you with
But
this?
here's the problem,
So
though.
we have a very large interagency wholesaling group that we don't
Right.
talk about. As that, so now we're all interagents together and only people that know about what we're doing, blah, blah, blah.
The reality of it, the problem is, as soon as Jerry tells her admin assistant, who's not licensed, technically now it has to be put in the MLS, which it can't be put in the MLS.
But if everybody in part of that group is licensed, where does that stop or start?
As long as they're with the same company and it's truly an office exclusive, then you could do that.
You on that, Jerry?
Now, but Jerry,
There's a lot of licensed realtors in here.
you're going to
that
have to
would
find
be
out if
a
your
part
broker
of that.
allows them, though. That's the thing.
She's the
A lot of
broker.
brokers don't allow it. So, there you go.
I had trouble, man.
Ted?
I'm a broker too, but I'm just, yeah.
Great questions. I'm having fun. Hold on a minute.
Hey, please use Mike.
Something that Ted said about like a finder's fee or referral, isn't that not allowed when the wholesaler is not licensed? They cannot receive a referral fee? Okay, so you can't get around that.
They can get an advertising fee. Marketing.
Wait, well, it's something different? Okay.
That's what I heard anyway.
Okay.
Back in the day, not anymore.
Okay. Okay. And so I work for a company that does cash buying, mainly wholesaling. I'm not gonna lie, but we do some fix and flips, rentals, things of that nature. I mean, do we have to disclose what the property might be worth, ARV, when we're buying it from somebody, for a much bigger discount? When we're not gonna wholesale it, we're gonna keep it for ourselves. Like, where's the ethics in that?
So if you're licensed, then there is a duty to not mislead. One of the problems, if you're not licensed, like a lot of the wholesalers aren't, one of the problems that I see, if you're not going to infer in any way the market value, you haven't done anything wrong. What I'm seeing is, hey, your house is worth 125 and you know that it's worth 200. If you just say, I'm going to offer you 86,000 and the seller says, great, no harm, no foul. It's a business transaction. It's where we go that step further and we start misrepresenting the values.
So like when I say investors typically pay 50 to 75K for a property like yours, when I know that I'm building quite a decent margin there too, I mean, is that misleading? Is that unethical? I mean, how can they prove that? I mean, where is that?
There's the legal standard in its strictest sense, and then you guys always got to think about this. Can I defend my actions in front of a jury and win? If the answer is probably not, then you have to think about, maybe you're willing to assume the risk. That's your choice. But these are things you have to think about. Marketing fee, be careful. Because what the commission's going to do if there's a complaint, they're going to say, fine, you hired this person to market, but we want to see their track record of marketing. Did they do it for other people? Did they do it for you? Let's see invoices. You got to be real careful.
I've been off the wholesale train for a little bit now, so
I
I've been waiting for this conversation.
Yes, sir.
My name's Mike, and first off, I love cats, so.
I'm feeling
as sad as this sounds, I bought a property, I've had it for a year and a half and haven't rented it just because there was a bunch of feral cats there.
Right on.
So,
They should give you a free membership just because of that. Ted?
Anyway, so I don't consider myself a wholesaler by any means. I'm a licensed contractor, and I run into I create my own deals. You said be creative, and I buy a lot from houses that are going to foreclosure. I'll manipulate an estate that there's nobody around, and I got a couple of things here. So if I were to come in here and say, oh, I have this property at 3616 South 96th Street, District 66. I bought it and I'm going to sell it. I've owned it for 2 months. My intent was to, keyword intent, because back to you said a minute ago, judges, if you can be in front of a court, that's what they're going to look at, is your intent. My intent was to fix it and then sell it. I get people that come and say, hey, will you sell it to me? At what point does that threshold, can someone say, oh, he's just wholesaling because
Sure.
he bought it, whether I have it in title or not?
Right. Great question. And is it going to be an assignment contract?
No.
Or is it going to be a purchase contract between you and the future buyer? What I would do, and I'm sure you're doing this, and that is you have a purchase contract with the seller, and then he comes along and you say, listen, I'm closing next week, and then if you want to buy it, and he says, great, and you guys negotiate terms, and you do a purchase contract between you two, and you put a contingency in that purchase contract with him that says that our deal is contingent upon the successful closing. It's showing and demonstrating intent that this is not a wholesale. But if the commission even infers that this is a wholesaling transaction with an assignment, and you're not within the realm of the legalities, then you're subject to jeopardy.
So I can say that I've never assigned a contract or never worked with a contract assigned to me. Al Nelson at Trustworthy Title, he does all my stuff, and he knows I get kind of crazy on stuff. He said, Mike, I get a lot of people that bring me some crazy deals, but I don't think you ever brought me a normal deal. So,
just don't assign it. Don't use an assignment contract.
So I guess I asked him just this today, do I have to close on it myself, so I have it, own it 100, and then sell it to this guy, or can I just double close? I've had it for 2 months. The guy's dead, so it's a court thing.
There's going to be a double close. Otherwise, I guarantee you they're going to view that as a wholesaling transaction.
Okay. So back to the advertising thing, if I come in here and I give an address, because we're all like-minded, we're not all licensed the same as brokers or realtors, is that still a breach of the real estate commission? Are you going to frown on that?
It could be, depending on how it's structured. And you're going to get, if you ever get called out on it, then you're going to have to show, they're going to take the flyer because you'll get turned in.
Well, I wouldn't put anything on paper. Hypothetically, if I were to say 3616 South 96th Street, if I were to say something like that.
Yes.
And it's on tape, and hypothetically, if I were going to randomly, does that count as advertising and marketing?
It does.
Okay, so then I won't do that.
Ricardo. He keeps promising to take me to Machu Picchu, but every time he goes to Peru, he stiffs me and never takes me. Way to go.
So if you're planning to close, can you advertise before you close?
Maybe.
If you are planning to close and it's like a week away, can you advertise before it actually closes?
Again, it depends. If you are marketing it and you can, here's what I'm going to tell you with this. There is no precedent yet that the Real Estate Commission has established on that very answer. So there is no answer. Is there a distinguishing factor between, is this an assignment or a double close with 2 purchase contracts? There is a huge distinction. But right now, the way I see it from a risk management point of view and where the commission is on this, the commission members are made up of real estate agents except for the one public member, and they are wanting to hang people. Are you going to be that first case? I mean, that's the assumption of risk. My opinion is from a 100% risk management that I think there's jeopardy there and I wouldn't do it. If you want to be the one that goes in and fights it, that says, listen, I understand the rules, but my intent was to do a double closing. I wasn't selling my equitable interest because I was going to close and then close again. Maybe they'll go for it. But there's no answer to that question objectively at this time. Yes?
So you've stated that you think this is going to shut down wholesalers pretty quickly. What are the actual penalties that they're, looking? What's the monetary penalty?
Sure.
If they get caught for something along these lines, what are they looking at?
So the max that the Real Estate Commission can nail you monetarily is $2,500. And then if you're a licensed agent, there could be dum-dum school and classes and stuff like that, or revocation of your license. If you get caught a second time or third time, they can refer it to the Attorney General's office for practicing law without a license, which is a felony. So that's a great question, because I actually get that question all the time, to be honest. I'm going to do it until I get busted. What are they going to do to me? Assumption of the risk.
We'll do this as the last question, and then if you guys got further questions, we're going to be able to hang out at the restaurant, and we can talk further there too.
Real quick, if you have a pen and paper, I'm going to give you my contact information. Feel free to reach out, whatever issue you have, and then we'll get to your question there. But my telephone number is, my cell phone is 402-660-0395, 402-660-0395. And then my email address is paul@randallschool, RANDALL, randallschool.com. Yes, ma'am.
So we're not dealing with multiple transactions. So if I buy multiple houses.
Oh, step up a little.
Okay, sorry. So if I'm not a broker or I'm not an agent and I do multiple transactions, I buy lots of houses and sell them. We're not dealing with anything along the lines of multiple transactions, though, correct? As I'm just a buyer. I'm a buyer and a seller.
Okay, I'm not following.
So yeah, I'm a FISBO.
So
I'm buying stuff at foreclosure auctions and selling them.
Sure, as long as when you pick it up, if you close, so you are the legal title holder.
Yeah, I'm the owner.
Then you fall under the FISBO exemption.
Okay.
But as soon as it's that equitable interest, that's when you find yourself in
jeopardy.
jeopardy.
So I'm a foreclosure guy. I buy them at the auctions.
Then you're
sell
good.
them off to Joe Blow.
You're good.
All right. Okay.
One other thing before we go that I wanted to bring up, just an interesting tidbit here for any lawyers that are in the audience. The law says you must be licensed or use a licensed individual to market your equitable interest that was gained through a contract. Purchase contract, lease contract, whatever. If somebody ever wanted to fight this, I think there's a winning formula if they wanted to pay $100 grand to do it. We're a deed state. So when you go to the bank and you borrow the money, and there's a loan against the house, you don't have legal title. You have what? Equitable interest or equitable title, because the trustee has the legal title. And a deed of trust, trust deed of trust is a legal contract. So they didn't really specify it. So if there's any lawyers out there that want to do it pro bono, think there's a legal thing there. Think about it. A mortgage, it's a legal contract, right? So well, with the mortgage, you do have legal title, but with the deed of trust, you don't. You have equitable title. The trustee has legal title. I brought that up to the MLS board members, and they didn't care, so I tried.
Awesome, Paul. Give me a big round of applause for Paul. Wow, lots of content there. This will all be on a video on our Facebook page too. So we'll recap this and kind of go over it. I know the amount of content that we just got was kind of overwhelming, but thank you for that, because that was absolutely amazing. And I know there's a lot of questions out there. That's why this room's so full. That's why we have 115 people in here trying to soak up as much as we can. And I think we've had as many as 50 people watching online. So there's a lot of people interested and a lot of unknowns, right? So we appreciate that very much. So to conclude, take care of your staff. Watch out for our events on our Facebook page and our RIA site. We got a lot of things coming up. And again, we're going to be here through this year. So you know where we're at. Don't need to check the site. And we're always on the first Tuesday. First Tuesday is September 6th. It's the day after Labor Day, just so you guys know. So have a great night. Thank you, Paul. Drive safe. Hope to see you guys over at Burger Theory afterwards. Thank you. Take care of your staff.